So again, I am Lindsay and this is High Seer Legal, and today we're going to go over your estate plan. So there are many different types of trust. This whole masterclass is about the revocable living trust, but I want you to be aware that there are other trusts out there. There's an irrevocable trust, a special needs trust, spendthrift trust. There's hundreds of other different types of trusts. These are the big four that most people think about, but today we're just going to go over that revocable living trust and how that benefits us in estate planning. So who plays a role in the trust? So this is good to know of what these terms are and what are the roles in the creation and the management of an estate plan or a trust. The first one is the trustor, and that is you. So you are the trustor, or settlor is also sometimes what they're referred to as grantor, that you are creating the trust. You are creating this trust. You're going to transfer all your assets to this trust. You are creating this trust for your benefit. Typically, it's for your benefit, maintenance, welfare, to take care of you during your lifetime. Also, initially, you're typically the trustee. That is you managing your stuff. And it's kind of a weird concept because you're like, why am I giving me my stuff to manage? Well, it's kind of like forming a family business for yourself that, you're going to form the family trust business essentially. And it's going to be like an ice cream shop. And you're going to put all of your assets in the ice cream shop. You're going to manage the ice cream shop every day. And then the event when you're unable to or no longer with us to manage that family trust ice cream shop, your new trustee comes in and manages it for you. And that's what we call our successor trustee. And that's who takes over the trust when you're either incapacitated or unable to manage the trust because you're no longer with us. So again, you have you as trustor creating this trust, with you as the initial trustee managing this trust. And if you're not available, then we have our successor trustee to come in and manage that trust for you when you're either incapacitated or no longer with us. With that, we have our trust beneficiary, and that's where's it going to go after you're not with us? Where do you want it to go? And that's kind of the benefit of a trust, that you're able to provide where those things go. You can put parameters in there. You can put designations. You can put gifts within that beneficiary designation in your trust. And that's the cool thing, is that you have control. It's not just, this person, if they were a direct beneficiary on an account, gets the full amount. You're able to control how that distribution occurs. So say, for instance, you have younger children, or you say you have a 20-year-old and you have, $1 million estate. If you have direct beneficiary designation set up, which some people do to avoid probate, they'll have on a life insurance or their investments, a direct beneficiary. And that is great because that does avoid probate. The disadvantage of that is that if you were to pass away and your 20-year-old was that beneficiary, well, they get $1 million lump check. And I don't know about you, but at 20, I'm getting a Porsche. So that's where the trust and the estate planning is kind of beneficial, is that you get to have that control, that you can say, well, hey, I have a younger child. I want them to have only 20% of this trust for educational purposes. At age 25, they can get an additional 25% for additional education or a down payment on a house or a business. At 30, they get an additional 30%. And at 40, they get the rest of the trust. You get to kind of make those controlling decisions from beyond the grave, which is kind of a cool thing, as opposed to this person just having lump chunk sets and not, going wild. So that's your trust beneficiary designation there. Within the estate plan, we have powers of attorney. So we have agents who are going to make those decisions, and we'll go over what powers of attorney look like, but we have that agent designation there. And then with our pour over will, we also have the executor who's going to make those executive decisions on our pour over will and our end of life decisions for burial or cremation. Okay. So what exactly is an estate plan? So we have a couple documents here in our basic estate plan. The first one being our actual trust agreement. And so that is the creation of the trust. That is what we are using as our controlling document of how we manage it. That is the controlling document creating this trust. Okay. Again, it's going to have the 5 components like we talked about. We're going to have the trustor, which is you, the trustee, which is also you to manage the trust, what we're going to call the trust, the name of the trust, and you can name it anything you kind of want. Typically, most people call it their last name, like the Smith Family Living Trust, or, I have mine as my game handle just because I'm a nerd. We can, put that on there. People have their initials. People can kind of call it whatever you want. Typically, it's going to be your name. With that, then, so we have the trustor giving the trust or creating the trust. the trustee managing the trust, what we call the trust, and then where does that beneficiary designation go to? And then who's going to manage this trust when you're not able to? So those are the 5 components of a trust. Pretty simple. We like to include some other, parameters within that trust agreement of how do we manage this trust, any kind of special parameters or authority to manage that trust assets. Okay, but that is a trust in a nutshell. Those 5 components again: trustor, trustee, successor trustee, what we're calling the trust, and the designated beneficiaries. Okay. With that, because there is private information contained in that trust agreement, we have to show authority that this trust has been created. And that's what, these institutions want to see, that, hey, a trust has been created, and they need to put on there that their trust has a beneficiary, and that would be our certificate of trust. So the certificate of trust is kind of the Cliff Notes version of the trust itself. And all it is showing those salient information of who the trustor is, who the trustee is, who's going to manage the trust, and what the trust is called. So sorry. Having coughing fit. Of course, in the middle of the presentation. Tis that time of year. Okay. With that, then we have our pour-over will. So a pour-over will is a document that's not like a typical will like we think about. I'm so sorry. This presentation's going well. Sorry about that. So with the pour-over will, the pour-over will is for items that are inadvertently left out of the trust. In a perfect world, if we do everything correctly, we should never have to use the pour-over will. How this document typically functions is that, say, for example, we had a client who had a trust, did everything perfectly with the trust. She funded the trust, she transferred all the assets to the trust, she was managing the trust perfectly. And not anymore, but a couple years ago, interest rates were really good. So when you refinance a house, title company will make you take it out of the trust to refinance. So, client did just that. She took it out of the trust, she refinanced, she got that 2.5%, which is great. Title company is supposed to put it back into the trust. Title company forgot to put it back into the trust. Mom goes on with her day thinking everything is great. Mom passes away. Kids are like, great, we have a trust, we can take care of everything. They go to sell the property, get to the end of escrow, they do title run, and they go, ooh, you have no authority to sell this house because it is in mom's name only and not the trust name. So where the pour-over will comes into place is that the executor of that will then do a very quick probate petition with the court and say, hey, mom had a trust. Mom did a great job of transferring everything to this trust. She did not want the kids to go through probate. Hey, court, give the title company the authority to go ahead and put this into the trust to be handled by the trust. That's why it's called a pour-over will, because it's going to pour it back into the trust to be managed by the trust. Okay. So it's not a typical will like, so-and-so gets this, so-and-so gets that. What it's saying is that all assets that you have, you want the trust to manage. You want all the distribution to go to the trust because you never wanted your heirs or the people named to ever have to go through probate. So it's kind of your catch-all document. Again, if everything is done correctly, you should never have to use that document, but it's important to have just in case something like that scenario happens. Okay. With that, we have our community property agreement. We're in a community property state, or if you live in a community property state, this is saying that you want the community aspect of your marriage, the community property aspect, and the separate property management to be managed by the trust. That's what that document says there. With that, we have our personal property memorandum, and that is saying our personal items that typically do not have a title. Our furniture, artwork, china, dishes, all our household furnishings, our clothing. You're saying that you want the trust to manage those personal items as well. Okay. And then with that, we have our property deed, and that's our big real property assets. We're wanting that deed to then transfer it to the trust. So those are kind of the basic 6 documents or 5 documents if it's a single trust that go for your basic trust creation. Again, our trust agreement that creates a trust, our certificate of trust, which is the proof or the abstract of the trust that the financial institutions will take a copy of, the pour over will for anything that got inadvertently left out, the community property agreement if you are married, for a joint trust or family trust for those community property aspects of the marriage, and then our personal property memorandum, which is our personal items, and then the actual property transfer of the actual real property. Okay, so those are basics of the basic trust creation. Okay. With that, however, is we have other assets that need to be managed. And I don't know why this isn't going. There it goes. In the estate plan, and we have additional documents that really kind of full out the estate plan that take care of all the scenarios. So this is just our basic creation that takes care of most of the things when we are incapacitated or pass away. With this, now we have the additional authority for our agents or our successors to take care of these things. And the first one is our power of attorney. There are two different types of power of attorney. Typically, there is a financial and a medical. And again, powers of attorney live. When we die, they die with us. So always keep that in mind. I have clients who are like, but I have mom's power of attorney. And I always say, well, that's nice, but mom's not with us anymore. And because of that, the power of attorney goes along with her. It's no longer with us or active. So again, it lives when we die, it dies with us. So these are decisions, again, while we're alive, but unable to make those decisions. So the first one is our financial decisions. Again, for financial matters that need to be taken care of while we're alive, but aren't able to do so. So either we're in a coma, we're, acting a little wackadoo, talking about that beachfront property in Arizona. This is saying that we're giving the authority to our agent to handle those financial decisions while we're still alive, but unable. And those are usually our day-to-day things like paying the mortgage, paying our taxes, bank accounts, the normal kind of everyday minutia that we need somebody to take care of for us. Okay. Within that document, there are two ways that document becomes active. The first one is durable, and you may have heard that term durable. What it means is that now. It means regardless of your capacity, ability, willingness to take care of these things, you're giving that person the authority, if they had that document, to go ahead and take care of these things for you now. Okay. Some people really like that quick accessibility. If there's an emergency or something like that happens, that they would want that durable designation of when this document works. The other option is what we call springing, and that is kind of more of an insulating provision that before your agent would be able to go ahead and take care of these financial decisions for you, they would need to first certify or get a doctor to certify that you are unable to make those decisions. So they would have to go to a doctor and say, hey, she's obviously not able to take care of these things, or he's not able to take care of these things because they're in a coma. They're acting a little weird. A doctor will certify that, and that certification is going to go with that power of attorney, and that is springing it into action. That's why it's called springing. So some people really like that insulating provision, that somebody would have to get that certification first before it becomes active. Okay. So those are our two abilities of how these documents or the financial decisions are made, either durable or with springing. Next is our medical power of attorney. So this is for our medical decisions. Again, while we're alive, but unable to make those medical decisions for ourselves. And that document is always durable. We want that to be always active because if you're not able to advocate for your medical care, you're probably not able to do much of anything. You're probably in a coma, or you're really not medically or mentally with us anymore. So that is always durable because we want it to be available if there's an emergency or something is happening. And within that, you get to make medical decisions about your care, that if you're unable to advocate for yourself, what would happen in certain scenarios. And the typical certain scenarios are, the first choice is that you want everything to be done for you, regardless of outcome, hope, survival. I call it the Bionic Woman Clause. That's usually the first designation you can choose, is that you want all those things done for you. With that, the scenario of if you're in a coma and you're not going to make it, do you still want that life-sustaining treatment to be used? Similar to that, if you have an incurable terminal condition, I would say level 75 cancer, that you do not want those life-sustaining treatments to be used. With that, there's always a designation of artificial nutrition or hydration, that you want to receive those things regardless of anything else that you've chosen. Also in the document, you'll have a option for your agent to make those decisions for you that, yeah, if the burdens outweigh the cost or the benefits, they'll make that decision for you, that you're giving them that authority. And then always within these documents nowadays, we have our pain relieving medication, whether you want to receive those things or not, for your care. So those are kind of the basic 6 decisions across the board on powers of attorney. And typically you can pick more than one, whatever feels good to you on those. Also, there's ability to put provisions in there if you have any kind of religious beliefs, or anything like that, that you need to have doctors be aware of. You're able to include that within your power of attorney for medical decisions. Okay. So those are kind of how the powers of attorney work and function there. So again, we have a financial and medical, and always keep in mind that those powers of attorney live with us. And when we pass away, they pass away with us. With the additional documents in the estate plan are included as our living will. And a lot of people have this misconception that, oh, I need a living will. Well, they're thinking of another last will and testament. What a living will is it's our end of life decision. So it's our do not resuscitates essentially. It is what happens if you are at that point where they may have to do CPR or they might have to do some kind of heroic matters. You're saying that you do or do not want those matters done for you if it prolongs your passing or does not prolong your passing. So that's the decision you make in your living will, if you will, no pun intended. And it also includes if you want that artificial nutrition or hydration. So that's what's included in that living will document there. Okay. The next document is our authority or declaration of remains. And this is a very important document because it gives somebody the authority to order your burial, cremation, composting, whatever you like. It gives the mortuary the certification, if you will, or the authority to allow this person to order that for you. It's an important document for them to follow because it kind of gives them the authority that this is okay, that this is a person who is able to order this and that they're following your wishes. Importantly, with that in that document is if you are cremated and somebody needs to pick up your remains, your ashes, it gives that person's designation the ability to do so as well. And apparently this is a big thing, but a lot of people fight over ashes, and I never really thought about that, but I guess it makes sense. So the mortuary loves to have this document because it covers them on their ordering and releasing of people who are passed who can't speak for themselves. So that document is very important. With that is your burial or cremation instructions. What do you want to have done with you? Do you want to be buried or cremated? Do you have pre-purchased plots, military plots, Neptune Society? Do you want to be composted? Do you want to give anatomical gifts away? Do you want to do any of those things? Again, informative for your successor and agent to put where you want to be placed or gone to. Okay, so there's no guesswork, if you will. And then the final document kind of in this whole packet as well is our HIPAA release. And that's our medical record release for your agent to be able to get your medical records if they ever needed to on your behalf for, say, litigation or a med mal or anything like that. That gives them the ability to get those documents. So again, our basics of a trust is that trust agreement, our certificate of trust, that pour over will, community property agreement if we're married, personal property memorandum, and property transfer agreed. To fill out the full estate plan, we like the additional documents of that power of attorney, both financial and medical, to make financial and medical decisions again while we're alive but unable. That living will, that end of life decision making document, the authority or declaration of remains to let the mortuary know what's happening, processing and pickup, if you will. The burial instructions of where you want to go or what you want to have done for you, and then that HIPAA release. Okay. So those are the basic estate plan there.